Hello, I'm Angela Princewill. I'm a family law lawyer at AP Lawyers, and today I would like to talk to you about amending your pleadings. And by pleadings, I'm talking about your family court application, your answer, and the reply. So often there's this misconception and I guess concern among self-represented parties or even new lawyers about, amending an agreement. And I just want to set straight what the rules have to say about that. So if you filed an application and the other side hasn't responded yet, then it's okay for you to amend your application. And there's the rules, the family law rules set out how to do that. But all you have to do is amend your application. You don't have to ask for the court's permission or consent from the other party, the respondent. If there's been an answer filed, then you will need the consent of the respondent to make any changes to your application. And why would you want to amend an application? Well, usually you would want to do that if you forgot to include a request from the court. So if there's something that you would like to ask the court, but you didn't include in your original application, then you want to amend that, amend the application to include that. If you think it's appropriate that there's material facts that absolutely have to be pled in your application, then, and you did not include that, then obviously you would need to amend your application for that. Or maybe you just want to take out, a claim that you made and you no longer want to pursue. So those are some of the reasons why you'd want to amend your application or answers. But back to what I was saying, if there's been no answer filed, you can amend it in the form prescribed by the rules. If there is an answer filed, you will need the respondent's consent. If you're the respondent and you want to amend your answer, then you can do so within 14 days of being served with an amended application. So in which case you've been served and now the applicant amends their application. Whether or not you've previously filed an answer, you have 14 days to amend your answer. But what happens where, it's not an amended, where there's no amended application? In that case, you also need consent from the other side. So for the most part, usually if you want to amend an application or a response, an answer, you would usually need the consent of the other side. And a lot of times people get tripped up and do not want to give their consent. And it's usually out of concern for what the other party wants to do. There's obviously distrust on both sides. And there is that apprehension that someone's trying to maybe pull a fast one and things like that. And I want you to understand that it's almost a right to amend an application. The rules, and I'm just going to read exactly what the rules say actually, because it expresses it so well. It says on a motion, so the party that's seeking the change will have to bring a motion to the court. The court shall give permission to a party to amend an application, answer, or reply, unless the amendment would disadvantage another party in a way for which costs or an adjournment could not compensate. So the courts will grant a request made on motion by a party, whether the applicant or the respondent. The courts will grant their request to amend their application or their answer. The courts would grant it, except granting it will disadvantage the other party in a way that cannot be compensated for by costs or an adjournment. So the mere fact that a person wants to amend their application and that doing so would mean, a delay in the process would mean now you have to respond to one more claim that in your mind you might believe is frivolous and it's just unnecessary and this is just a waste of time and it's a tactics and it's just, I want to move on. This is going to disadvantage me in this, that, or many other ways. that's not going to prevent a court from granting that request, because the courts recognize that amending the pleadings may disadvantage you. It's only a disadvantage that cannot be compensated for by way of costs or by an adjournment. So that would prevent the courts from making an order granting the request. So, for example, a huge concern is if I allow the applicant to amend their application and bring another claim, then now I have to respond to it, right? Which is a fact. You do have to respond to it, but that's something that can be compensated for by way of a cost order. If you think, oh my God, if they bring this claim, I don't have time to respond to this claim before the next court date, for example, granting of an adjournment is a ground, is one of those. It's something that is a tool that can be used to deal with that disadvantage, right? So for a court to refuse to grant that adjournment, to grant that amendment, I meant to say, it has to be a disadvantage such that, cost award or an adjournment would not be able to compensate you for that, for the amendment that they're seeking. So when you're faced with a request for an adjournment, unless these factors exist, I strongly encourage you to consent. There's really honestly no point to putting forward these resources or taking the time to go to court to ask for the party to not get that amendment. The only time that would be justified is if there's, again, a disadvantage that cannot be compensated for by way of costs or an adjournment. So a better strategy, in my opinion, would be consenting to that adjournment and then asking for costs or something like that to compensate you for the additional resources that you've had to put towards amending your answer in